A man bought a car in 1960. It spent more time in the shop than on the road. He had no legal recourse. The 1950s and 1960s marked a turning point in American manufacturing. Cars rolled off assembly lines in unprecedented numbers. But quality control was inconsistent. Defects were common. Warranties were vague, often one-sided. If a vehicle failed weeks after purchase, the buyer absorbed the loss. Manufacturers faced almost no legal consequence. By the early 1960s, consumer frustration had reached a threshold. People who'd spent their savings on new vehicles found themselves stranded with defective products and no remedy. The legal system offered little protection. Contract law favored manufacturers. The doctrine of caveat emptor, let the buyer beware, still dominated. Consumers had signed away their rights before they even left the lot. Massachusetts acted first. In 1967, the state legislature passed the first Lemon Law. The statute was direct. If a manufacturer couldn't fix a defective vehicle after a reasonable number of repair attempts, the buyer could demand a refund or replacement. No other state had done this. Massachusetts didn't know yet whether the law would hold up in court or whether other states would follow. The law worked. Manufacturers suddenly had financial incentive to improve quality. Defect rates dropped. Other states noticed. By the 1980s, Lemon Law variants existed across the country. The federal government codified protections in the Magnuson-Moss Warranty Act of 1975, which required warranties to be written clearly and enforced fairly. What began as Massachusetts frustration became national consumer doctrine. The mechanism was simple but revolutionary. Lemon laws shifted the burden of proof. Instead of consumers fighting manufacturers in court, the law created a presumption. If repair attempts failed, the product was defective by definition. Manufacturers had to prove otherwise. This inversion changed everything. It made warranties mean something. It made quality matter to the bottom line. Today, Lemon laws apply beyond cars. Electronics, appliances, and other consumer goods fall under similar protections in most jurisdictions. The principle persists. Manufacturers who sell defective products must provide recourse. It sounds obvious now. It wasn't in 1967. One state's decision to protect its citizens became the template for consumer protection nationwide. This video is for educational and informational purposes only and is not financial advice. Always do your own research. Subscribe to see how everyday consumer protections came to exist, each one a response to a failure that cost real people real money. Subscribe to uncover the hidden histories behind the consumer protections you use every day. This video is for educational and informational purposes only and is not financial advice. Always do your own research.